process of doing away with slavery pressed that they count for zero. Now this fact, I think, is most inconvenient for the normally circulated account of the meaning of the 3/5 clause. Now let me give you just a piece of background about this clause. This clause arose actually under the Articles of Confederation, the Constitution that was in place before the Constitution. It arose under the Articles as part of an attempt to come up with a formula to calculate how much each state should pay into the budget of the Union to cover the costs of running the government. Now, the original plan under the Articles of Confederation was that the central government would assess the total wealth of each state and charge them in proportion to their total wealth. Now, this is a daunting task at any time. As you could imagine, go around and, count up all the horses, count up all the acres, count up how much production of stuff there is. That would be daunting, but it's really, really, really daunting in the middle of a civil war, of a war, which is what they were in the middle of. So they came up with the idea of using population as a more readily ascertainable surrogate for total wealth. They took this, they took to this idea because they had the idea that human labor is the chief source of wealth. But how count slave labor? Everybody agreed that slave labor was less productive than free labor. Why? Because everybody recognized that people work harder when they get to keep the fruits of what they produce than when they're taken from them. So Southerners thought that a slave was only 1/2 as productive as a free laborer. Northerners countered, I should say, with an estimate of 2/3. As a compromise, they settled on 3/5. That's where this number comes from. At the Constitutional Convention, the issue came up because one of the early and most important decisions taken provided that representation in the lower house, the House of Representatives, would be in proportion to state population. So again, there was a necessary spillover of slavery into the Union and its Constitution because something would have to be decided about how to count the slaves. Now, the idea behind population proportional representation was in part that each slave should be represented to the degree that reflected its relative wealth, power, and influence. That is to say, many of the same considerations that went into the original formulation of that 3/5 clause under the Articles. So after some back and forth debate at the Constitutional Convention, they settled on 3/5 for many of the same reasons that had been agreed to under the Articles. So now, in surveying these constitutional provisions that directly touch on slavery, what is striking, I think, is how few they are and how much they share one characteristic. They are the places where it was unavoidable that the Constitution take some stand on slavery, build in some power or policy with regard to that institution. And when it deals with the topic of slavery, the Constitution very carefully holds it at arm's length as a matter for and in the states. Otherwise, it stayed away from the topic. Now, this arrangement should, I think, be called an acceptance of a certain sort. Not the endorsement of slavery of the Neo-Garrisonians, nor the rejection of it of the Neo-Lincolnians, but an acceptance of the principle that it is up to the states. It's an acceptance only of a certain sort, however. The embarrassed circumlocutions in the text, as I've mentioned, the frequent denunciations of the injustice of slavery at the convention show, I think, all these together, that this was not an acceptance of slavery in the states as a matter of official indifference or neutrality with regard to slavery. So to give just a few samplings, Luther Martin of the slave state Maryland called for abolishing the slave trade because it was, as he put it, inconsistent with the principles of the Revolution. Slavery is accepted as a state institution, but at the same time regarded as an anomaly and incompatible with the principles of right endorsed in the Revolution and after. Nonetheless, the Constitution did very little about this incompatibility. In effect, it defers or postpones any decision for later and for elsewhere. The founding generation, as I've already suggested, acted in the hope that somehow the issue would be taken care of in the future. But we know what they didn't know, what the future actually held with regard to slavery. So finally, I want to come to my last point about the neo-Madisonian elements of the way the Constitution treats slavery, and that's what I call inevitability. And this is really the other main point I wanted to make today. I want to maintain that the way in which slavery was treated in the Constitution was inevitable, or nearly so, when we understand what they were doing the way they understood it. The first and really central point, I think, is this. In making a Constitution, they thought they were making a federation, not a nation. They were making a union of otherwise independent states for certain limited but quite important purposes. The internal ordering of the members of the Confederation was not one of the accepted purposes of such unions, and hardly anyone in 1787 thought that that was what was involved in making the Constitution. No one thought that the convention or the union it was constructing had the power, had the right, or had the responsibility to settle questions about the internal ordering of the states. Abraham Baldwin of Georgia made the point when he intervened in the discussion of the slave trade and said that he thought national objects alone to be before the convention, not matters such as slavery, which were of a local nature. That in itself made the rest more or less inevitable. But there was more to it than that, and that more reinforced the same point. The two leading structural principles of the new Constitution were a new kind of federalism and a new kind of republicanism. The new federalism involved, again, I hope you learned this in high school or here or somewhere, the new federalism involved direct interactions between the government of the Union and human individuals within the member states. Interactions that had never been characteristic of federations in the past. But the condition for this unprecedented kind of interaction is a very clear line of demarcation between matters of rightful concern to the general government and all the remaining concerns of the states. The new federalism reaffirmed the general idea that matters of internal governance are not matters for the general government, and this reaffirmation was particularly necessary because of the deep intrusiveness of the general government into the member states. The republicanism of the Constitution, like every form of republicanism, was a commitment to self-government. That means that other units should not make decisions for a self-governing republic. That thought reinforced the division of authority that the new federalism had pronounced. So, the way slavery was treated in the Constitution was perfectly in accord with and in a way required by the nature of their task of union making and by the two principles, federalism and republicanism, that they adhered to. So despite the Neo-Garrisonians' 18 or more clauses, slavery was not, in fact, a central theme of the convention, and all of what was done with respect to slavery was pretty much a side effect of other things that they were doing. That is not to say that they saw slavery to be insignificant, far from it, but they saw it as a matter for the individual states and not for the Union. And in 1787, as I have tried to emphasize, they had at least some good reason to believe that the states were on a trajectory to do something about slavery as an institution that was incompatible with the free kind of regime they were trying to establish. So, I'm coming to my conclusion now. So to conclude that the best way to characterize the place of slavery in the Constitution and in the Constitutional Convention is in terms of inadvertence, deferral, and avoidance, is not to deny that the issue played a major role in the travail of the American Republic and could perhaps have been predicted to do so. But, strikingly, none of the leading men at the time of the founding did so predict. It was not until the crisis over Missouri in 1820 that it became clear that slavery was going to be a major challenge to the American order. The reasons why nobody foresaw this should, I hope, be clear from my talk. There was first the expectation or the hope that the issue would take care of itself with the growth of enlightenment, liberal values, and humanity within the states. Secondly, the founders thought that they had provided for all the spillover places in the new order. In this, they were much mistaken. Many more such arose, requiring fresh constitutional level decisions in much less favorable circumstances. Questions like the fate of slavery in new territories, the role of the Postal Service in spreading anti or pro-slavery opinion, the role of free states in relation to the unanticipated efforts to enforce the Fugitive Slave Clause. These and many other largely unprovided for issues arose in the post-founding era. And finally, there was also the novelty of the new kind of federal republic that they created. It was more of a nation than any previous federation, but it was still thought of as a federal arrangement with a limited need for a common moral sensibility. As was said at one point in the Constitutional Convention, referring to the Southern slaveholders, let their consciences be their own. That proved not to be possible. As Lincoln noticed, a house divided against itself cannot stand. Following some other sources before him. The original founders did not so much think of it as one house, however, but rather they saw it as a subdivision with covered walkways joining the different units. The new federalism in time filled in those walkways so that eventually it did feel more like a house than a subdivision. The result was that both the slave and the free states began to demand of the Union that it more unequivocally endorse their vision of moral truth. So the political struggle became a struggle for recognition as much as a struggle for concrete goods and gains. The original arrangement with regard to slavery, legal but not legitimate, became increasingly untenable. Political societies in general tend to work toward consistency between legality and legitimacy, and that effort provided much of the storyline for American history in the pre-Civil War period. Some Americans, like the abolitionists, demanded that the reigning legality be brought into conformity with the notion of legitimacy captured in the idea of a natural rights republic, that is, a republic devoted to rights. On the other side were those who attempted to redefine legitimacy to match and justify the reigning legal presence of slavery. They rejected the central idea of the natural rights republic, that being the equal endowment of all human beings with natural rights to life, liberty, and pursuit of happiness. Thus, our home state senator, those of you who are from Indiana too, rose on the floor of the body of the Senate to declare the propositions of the Declaration of Independence to be self-evident lies. So all of this brings us back to Thurgood Marshall and his bicentennial tirade against the founders. As I hope I have made clear, he had a point, although perhaps not as much of a point as he thought. The founders were not all-seeing or all-wise. Both history and their constitutional order developed in ways that they did not foresee, and for which they had not provided altogether well. Yet, I think he ought not to have been so harshly dismissive. After all, the vision of racial equality in the name of which he denounced them is a vision built on their commitment and their construction of a natural rights republic. That is to say, a republic where all men are held to be created equal and endowed by their Creator with certain unalienable rights. Thank you.